My name is Nate the Lawyer. If you are new here, we talk about the law and the facts. If you're about that life, don't forget to like this video, share this video, and subscribe to the channel. For all of you guys out there, we're going to go through the Johnny Depp and Amber Heard saga again. But today, we're going to go through the unsealed documents. And we're also going to talk about how some of the media are trying to manipulate this whole unsealed documents thing to try to make it seem like Amber Heard either won the case or that Amber Heard is somehow the true victim and these unsealed documents have made it. Now, Andrea Burkhardt, she was the one who crowdsourced the funding for the documents. It's 50 cents per page. It was like 6,000 pages. So it came out to like $3,000, a little bit over $3,000. She crowdsourced it. They got like $2,000 extra. They give it to the Children's Hospital, and we got the documents. And the only thing she did with the documents is correlate them, and she put them out for everyone to see. So we all saw the documents. We all saw what was going on, and we all saw everything was fully transparent. So let me give you a little bit more background. So the unsealed documents came out, and the unsealed documents are kind of what we expected. What Johnny Depp's team didn't want to come in, what Amber Heard's team didn't want to come in, and specifically, we're going to talk about their criminal history and prior bad acts. Now, generally, in any court case, you can't bring in evidence of propensity, or what it means. It's the once a thief, always a thief scenario. And that's what you can't do in a trial. So let's say if it's a criminal trial, I can't show that since you robbed the bank in the past, then that means you robbed the bank now, right? And so the law kind of says we don't like that type of evidence. Just because somebody did something bad in the past doesn't mean they did this bad thing now. So generally, the courts will say we don't want that evidence. We don't want to hear that evidence. Only thing we want to hear is the stuff that they did now to prove they did what they're being accused of. So in this particular instance, with these motions to eliminate, especially for crimes and other wrongdoings, most of these things won't come in to the trial. Even though they're salacious, most of these things would not come into a trial because it would just be unfair to the other side, right? Because like even with Amber's DV arrests, you'll see, just because she committed domestic violence against her prior partner doesn't mean she did it this time. But there are also exceptions to that rule. Some exceptions are, let's say if the party brings up themselves, like let's say if I'm convicted of robbery, and I'm on the stand and we're talking, and I say, well, I've never done anything wrong, then I can be impeached with that robbery conviction. And there are other nuances to it, but the general rule is prior bad acts can't come in. So I want to point us to two things in the motion. Let's start here. So this is from the actual motion. It's called a motion to eliminate. This was the motion to exclude particular evidence before it came to trial. So this says any evidence of testimony or allegations of criminal conduct against Ms. Heard should be excluded based on Virginia rules of evidence. Now, we don't have to talk about the rules of evidence because I'm essentially told you exactly what it was. The difference between someone, propensity evidence, someone has done something in the past, so that means they did this one, versus versus trying to figure out if the person did this particular act based on the evidence from this particular thing. So first, let's look at what Amber wanted to keep out. Now, it gets kind of crazy, but we'll see what she wanted to keep out. First, there are 6 things that she says her prior bad acts of criminal activity says she wants to keep out. First is her arrest for domestic violence. So under this section, she wants to keep out her domestic violence arrest when she was arrested for beating up her prior girlfriend. Here is that video of what happened.
Amber Heard was arrested September 14th, 2009 after she grabbed her then-girlfriend, artist Tassia Van Ree, and hit her in the arm during a clash at Seattle-Tacoma International Airport. A judge told Heard, who was going by the name Amber Van Ree at the time, that the state could still file charges in the future. Heard split with Van Ree in 2012 after 4 years together and moved on to actor Johnny.
So now this report by the Daily News was, I think, 5 or 6 years ago. But it's clear. Amber Heard was arrested and for assaulting her then partner, and she had a partner's last name. Now, this is what was reported in the news back then. Just because she was arrested, we know the news media reports a lot of a lot of craziness. So this is a recording from her court appearance with Miss Van Ree. I mean, because of this incident.
This is the state of Washington versus Amber Van Ree, cause number CPS 013-529. Stephanie Sato on behalf of the state. Ms. Van Ree is present in custody with counsel, and I didn't get your name.
Good afternoon, Your Honor. Michelle Shaw, and I apologize. I walked out of the courtroom, Your Honor.
The state is declining to file charges at this time.
Okay, what that means, ma'am, is no charges will be filed against you today. However, that could happen in the future. Therefore, we want to make sure we have your correct address. with Sycamore Avenue in Los Angeles, right?
Yes.
So you're notified by me if anything happens within the statute of limitations. Statute of limitations on a case like this is 2 years. So make sure that if the address changes, that you notify the clerk. Otherwise, it could result in warrants, and that would be a DV case, and that can have cross-state implications. So because you're in California, it wouldn't provide you any relief from the DV designation from the tomorrow.
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Pretty well, thank you.
Thank you, Your Honor. Thank you.
So just so we're on the same page, she was arrested, and then on top of that, she went in front of a judge, and the judge saw everything that needed to be seen. So we have Amber being, in front of the judge. We literally have that testimony, and everybody's there. That's what we had there. And I think it's clear. We all know what happened. Here is the cover page for the unsealed documents from Fairfax. And here it says, first, Mr. Depp seeks to introduce evidence related to the arrest at the Seattle-Tacoma airport in Kings County, Washington, where Ms. Heard was arrested and quickly released. But we know that she went and had a court appearance. She was arrested, had a court appearance, and then was released. And the charges, assault, Ms. Heard grabbed her partner's wrist to get her attention when the rental bus was leaving, were dropped. But that's not what happened. She said her necklace was ripped off. Again, this is changing the facts a little bit by Elaine. The charges were dropped, and the arrest record was expunged, which happens if you're arrested and you don't plead guilty. They say, okay, if you're good for, let's say, 2 months or 2 years or whatever that time period is, if it is, then you can get the record expunged because you were charged, but you weren't convicted. So that's what they expunge. And I think under the law, they allowed you to expunge that record, and she went and got it expunged. It is undisputed that no criminal charges were ever brought against Ms. Heard in Kings County. That's not true. We just heard that charges were brought, let alone resulting in conviction. That's true. There was no conviction. Therefore, evidence, testimony, or references to this arrest for the underlying alleged conduct is inadmissible pursuant to Virginia's. Now, I think Elaine makes a very good argument here that because this is propensity evidence, it shouldn't be allowed to come in to prove it. But again, Amber could open the door. And let's just also forget what we're talking about here. What type of case are we talking about here? We're talking about a case in which Johnny Depp is accusing his ex-wife Amber Heard, saying that she was the one attacking me, she was the one beating me. And on the reverse, Amber saying he was the one beating me. So this evidence is really on point. But you get into the thing where just because she did this to her former girlfriend doesn't mean that she did this to Johnny. So that's why the court, I think correctly, said you can't bring this in. But then Amber eventually opened up the door, and they were able to bring in not the arrest, but the incident. They were able to bring up the incident, but not the arrest. You'll see a little later. So this was actually kept out of the court documents, her prior DV arrest. Now, pleading guilty to lying in Australia. That was something that also they wanted to keep out. So first, I want to go to the English court. Remember the UK judgment, the one that they always say, UK judgment, this is the judge. The UK judgment is what happened. The UK judgment is the one we can trust. So I looked at the UK judgment when it came to this particular issue, because I remember when I read through those hundreds of pages, I remember the judge essentially said, well, hold on. There's a problem. She was convicted in Australia for lying to authorities. Here it is. Judge Nicholas, this is from his judgment, conviction in Australia for knowingly making false declaration regarding the importation of dogs to Australia, right? And he goes through the whole thing where the plane was met at Brisbane Airport by quarantine and customs officials. Ms. Heard completed the incoming passenger card, which included a question: are you bringing into Australia animals, parts of animals, etc.? Ms. Heard answered the question no. That answer was false, since Ms. Heard was accompanied by pistol and boot. So the judge in the UK case says there was a conviction, making false statements, and here it is, right? Here's what happened. Clear, right? I don't think there's any doubt, right? He still ruled in Amber's favor, even knowing that this conviction. And what did the judge say about this conviction? He says, again, in his judgment, the UK judgment, she was convicted, and the offense which Heard pleaded guilty involved knowingly making false statements. And Mr. Colligan said it was not a trivial offense. But this judge said that because the nature is so far removed from the evidence which Ms. Heard gave at the UK trial, that it wasn't relevant, that it was marginal at best. Her lying to authorities in Australia and being convicted of that was marginal at best, and he disregarded that damning evidence on her credibility as a witness, because remember, she was just a witness in that case, and said, I'm just going to disregard the fact that she was convicted for lying in Australia to that. So now when it comes to the Virginia case, back in Virginia, so now we're back in Virginia. This again is Amber Heard's motion to keep out the claim that she was convicted in Australia. And this is what they write in their claim, what they're saying. Again, to suggest that Ms. Heard has a criminal record and was found to be dishonest by a court, which is true, right? That's exactly what the UK judge just said. She was convicted. She has a criminal record. She was found dishonest by a court. As with the King County matter, quote, there was no conviction recorded, so they didn't record the conviction because the Australian court instead discharged the person, Ms. Heard, without proceeding to conviction. So now there was this is an issue that was going around on Twitter, whether pleading guilty or being found guilty equals a conviction. Now, in the United States, either one of these is a conviction. If you plead guilty, you've been convicted. If you're found guilty by a jury, you've been convicted. So conviction can mean either one of these two things. Either you were found guilty or you're saying, I am guilty. If you didn't plead guilty or you weren't found guilty, you have no conviction. So that is why here in the United States, you plead guilty, you've been convicted. There's no difference between pleading guilty and a conviction or being found guilty and a conviction. When it happens, you're convicted. But it seems what some people on Twitter are saying, well, it's not, it doesn't mean in Australia. It doesn't conviction just because you pled guilty to the crime and said, I'm guilty of this crime, doesn't mean you've been convicted. So, again, Australia may have different rules. England might have different rules. Canada might have different rules. But you have a judge who I think, because the Australian court system is pretty much based off the English court system, the UK, just like ours. And I have a UK judge who is favorable to Amber, who says that, yes, she was convicted in our Australian court, and this is proof. And now Elaine is coming forward and saying, well, she wasn't convicted, right? That's essentially what Elaine's saying, that she wasn't convicted, but you have the UK judge saying she was convicted. Who do you believe? Or is Elaine correct? Is the judge in the UK correct? Who knows? But I would say this. Let's just be honest. If she pled guilty to lying to officials in Australia, in the United States, generally that would be a conviction. So this is the second thing they wanted to keep out, this conviction for lying, and they were able to keep it out. This didn't come in the U.S. trial, even though it came in the UK trial. So interesting for Amber. So the first two things they were able to get out, the arrest for domestic violence and pleading guilty to Australia, that's gone. That wasn't introduced. Now, also this lying to the U.S. Department of Homeland Security was also not let into the American trial. So this is another thing Amber said she'd come out. So her arrest for domestic violence, gone. Her pleading guilty to lying to government officials in Australia, gone. Now her lying to the United States Department of Homeland Security. Now again, I'm going to turn back to the UK judgment, because this was in the UK judgment too. This was allowed in, and the judge actually looked at this. Think about this. The judge had two incidents of Ms. Heard lying to officials in different countries. Australia, and now we're going to talk about the United States one. So to challenge her credibility, the alleged lie was to the Department of Homeland Security regarding the status of Savannah McMillan. Now, just to put a bow on this person, Savannah, was coming into the UK and was stopped at customs, and Amber had to send a letter saying why this person was there. So Amber was saying she's just a friend, she's not an employee. But then her assistant said no, she's actually an employee, and then gave documents. So let's look at that just to show you what happened and what they wanted to keep out of the Virginia case. So on the 28th of September 2014, the letter was written by the Department of Homeland Security in these terms. Hi, my name is Amber Heard, and I'm a proud lawful American citizen, blah, 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 blah. She then goes on to say how Savannah is a personal friend and has never worked for her lawfully in the United States or anything else, and that she was essentially giving her money because she was her friend, not because she was employed. But Kate James, who was her assistant, who was Amber's employee, tells a different story. Kate James has been Ms. Heard's assistant in the United States. Ms. James, in a witness statement, said that the letter from Ms. Heard falsely claimed that Savannah was just a friend and not an employee. I'm afraid that I do not find Ms. James a satisfactory witness. This is what the judge said. He doesn't like Ms. James. She was dismissed, but essentially fired by Ms. Heard in February 2015. The circumstances for her termination are still appear to be a cause of rancor with Ms. James. So she's saying because Ms. James was fired, her credibility is suspect. And then he says she did exhibit her witness statement with a check for $16.25 made out to Savannah McMillan in her witness statement. And on that check, it said payments, right? Payments to Savannah McMillan. So think about this, people. And I think this is the important piece to this whole thing. Think about this. The judge in the UK said, well, I don't believe Ms. James because Ms. James is suspect. She was fired, so she's going to say anything to hurt Amber. But Ms. James said, okay, well, hold on. Just you don't got to believe me. Here's the check. Here's a check paid to Savannah for $1,600, and it says right here it was for payments, right? Payments for that. So she was her employee, right? You're just going to believe me. And the judge, even with that exculpatory evidence, some evidence that shows that what she's saying is correct, still said, well, since you were fired, I don't believe anything you said, no matter what evidence you bring. And you brought a check. That's crazy, right? That's crazy. So the judge totally disregarded Ms. James' evidence. She disregarded her testimony and just believed Amber. So that's essentially what happened. So in the Virginia case, then it came up again, right? Third, they wanted to keep this out. Third, the UK trial and witness Kate James, Ms. Heard's former assistant who was fired, she said the same thing. So they go through in a sentence and say the same thing. Her employment status, and says this should be kept out. The fact that she lied. But one thing I found interesting in this is that they never say in their motion that this was untrue, that Savannah was an employee. They just essentially say that it shouldn't come in because there was no conviction and nobody said that she's lying. But they never hear essentially say that Savannah didn't work for Amber. Let me just read it through real quick. Third, the UK trial, they go through this, included testimony related to Savannah McMillan, an assistant to Ms. Heard while filming in the UK, and the status of her employment relationship. So here, essentially, she didn't say she was her friend. She said she was her assistant, right? And her employment relationship with Ms. Heard in the U.S. Ms. Heard provided a letter to the Immigration Department in support of Ms. McMillan in 2014 after Ms. McMillan had been stopped and questioned at the airport. There were never any charges brought against McMillan or Ms. Heard of these allegations that Ms. Heard lied to immigration authorities about the true status of Ms. McMillan's employment status in the U.S. are not admissible and are excluded. Okay, so now what I find most interesting about this particular thing is that in the UK case, she was adamant that Kate James was lying. The judge thought that she was lying and that Savannah was never her employee. We don't believe that, right? Because it's suspect. Now, fast forward to the Virginia case, Kate James was her assistant, right? She said it right here. Kate James was her assistant, right? Look, it's line 3. Testimony related to Savannah McMillan, an assistant to Ms. Heard. I keep saying Kate James, but Savannah McMillan was her assistant. She was her, it sounds like she was her employee. So it's fascinating how in the UK, you're able to say Kate James is lying because she's not an employee. But then on the opposite end, say, come to the United States and says, well, she was an employee, she was her assistant, but just keep it out anyway, the fact that she lied about it. It was kept out. So the judge kept this out too. We didn't hear about this in that trial. We didn't hear about this at all. So lying to the Department of Homeland Security when she filed that paper to say she was just employing, that was it. That's done. The next one is Amber's criminal juvenile record. Now, this is interesting. Now, I do want to say this for everyone out there. Juvenile records are never relevant in any court case. And I think it's simply because what you do as a juvenile doesn't mean what you're doing is going to be doing the same thing as an adult. So the majority of court, if not all of them in the United States, juvenile records are not going to be used against you. Eventually, when you become an adult, they're sealed, and then it's like stuff never happened. So I think the court properly excluded this evidence of any juvenile record. But now since we kind of have some evidence about what happened, we'll see. So now, this record, I want to be very clear. This record I found online, and it just seems to be a simple traffic violation. Here it is. It says in 2003, a cop, while he was on patrol, he said He noticed that he saw a car. He noticed people weren't wearing seatbelts. He could see a strap hanging next to Miss Heard's side. He initiated a traffic stop, pulled Miss Heard over, asked her for her driver's license. She didn't have one. He found that her license was suspended, and he arrested her for having a suspended license. Now, I'm someone who hates misinformation. So just to be very clear, I'm not a Depp simp, nor am I an Amber simp. I just hate misinformation. And in this case, there's been some horrible misinformation portrayed against Amber Heard. And that horrible misinformation is that this juvenile arrest was for vehicular homicide, which everything that I've been seeing says it was false. Now, there's been many news articles, but Amber Heard's mugshot resurfaces and it claims that she was involved in a vehicular homicide case. And then they bring up some people who are saying that, but this claim, everything that I find about it has been false. The arrest for not having the suspended license, the one that I've seen was only for not having a seatbelt, and she got caught with a suspended license. That's what happens when you're driving dirty. Anything else, I've just not seen it. So maybe if you guys can send me something, or guys have found it, but I have not found it at all. I've seen something that said vehicular man, but I couldn't verify it. And then looking at the documents here, they're pretty clear that this was just, she just has a juvenile driving record for driving without a license. And that's what they essentially said here. Her juvenile driving record, including on a suspended license when she was a Texas teenager, it shouldn't come into play. And to be honest with you, that makes sense, right? It makes sense. Here it is, right? Here it is. So the first four of these things were kept out. Now, the arrest for domestic violence was kept out, but part of it came in. But this arrest for juvenile criminal record, that was going to go. Now, this is one that was interesting. Amber's involvement in a friend's death. Now, this kind of attaches to the last one, the Amber's juvenile record, and I'll show you why. So they put here, fifth, at deposition, which is true. At depositions, Depp's attorneys were asking these questions. So fifth, at deposition, Mr. Depp start cross-examining Miss Henriquez, that's Amber's sister, about the tragic death of Amber Heard's close friend, Logan. They don't put a last name, they just put Logan. It's kind of like Wolverine. When they were both teenagers and they were trying to figure out if Amber was in the car. Here's some of the questions. This is actually from the confidential transcript of Whitney. She was asking again some background. And was there a time when Amber and Logan's relationship became romantic? She says, no, they were never romantic. You mentioned that Logan passed away. When did he pass away? Again, this is Depp's attorney asking Miss Amber's sister Whitney about it. Question, did Amber ever tell you in her words or substance that she was driving the car the time he died? That was Depp's question. Her answer was, no, that didn't happen. And then they asked her, was Amber with Logan when he passed away? And at the bottom, you see no. So her sister totally denied that claim that Amber was involved in her friend's death. Unless there's more evidence, it seems like what the sister said was it didn't happen. And again, the motion to eliminate was put forward to say, well, let's just do this. In case they want to induce this, so they don't ask her sister on the stand, let's just keep this out. And I think this makes fair. You asked her, she says it didn't happen. Amber says it didn't happen. There's no evidence that it didn't happen. So it wouldn't be fair to put this in front of the jury because it's like, no, there's no real evidence that this actually happened, that she was with the friend. Now, there could be. Maybe it's just not admissible. But from right now, from what we're seeing, it's just not there. So right now, the claim that she was with the friend seems to be false, pending any more evidence that's induced. So now that leads us to our last thing, Amber's criminal record. So this last one was kind of just like any of the criminal stuff happened. Let's talk about this conviction for the dogs in Australia. She doesn't want this to come in.
And we all know by now that Johnny Depp and Amber Heard issued an apology, and she pleaded guilty, blaming her assistant at the time, or her former assistant, Kate James, and who is a native Australian. She said that in court that she thought Kate James had taken care of the paperwork. And she also blamed sleep deprivation and jet lag.
So that was for her arrest and pleading guilty. Again, she didn't want that in front of the jury. Next, she didn't want this in front of the jury. The arrest.
Amber Heard was arrested September 14th, 2009 after she...
So again, all these would be criminal things. So she said, hey, we don't want any of that to be put in front of the jury. And it makes sense. And the judge didn't allow most of that stuff, any of that stuff to be put in front of the jury. So they won. Now, because we've checked out Amber's stuff, Here is Mr. Depp's crimes and other wrongdoings that he didn't want to be put in front of the jury that weren't elicited in front of the jury. So let's look at this. This is his motion to eliminate to exclude testimony regarding his prior arrests and incidents of violence. Now, again, you may be saying, well, again, Nate, this is relevant to this case, right? If he's got incidents of violence, especially with other women and other things, then that may, be relevant to this case. But again, remember what I told you earlier about propensity, about the law doesn't want to convict you about things you've done in the past. It wants to convict you about if you've done this thing now. So that's why these things were not allowed in court. Just the same thing like Amber. Like Amber's DV arrest would have been highly relevant, but it would have been highly prejudicial. And the same thing with Johnny Depp. He has some things that would be highly prejudicial.